Hello students, hope everyone is doing great. Today we can have a session on SEBI Act 92. So this portion is there for CA Final, CMA Final and CS Executive. But this session is primarily focusing on the students of CMA Final who are of 2016 syllabus. Okay, so there are three parties in SEBI. Number one is issuer, number two intermediary, number three investors. So SEBI will be basically catering the need of these three parties. Okay, so we'll move to the basics of SEBI. So SEBI was constituted as regulator of capital market on 12th of April 88. It was not a statutory body at that time. Okay, so at that time the market issue or the issue of securities or securities market were controlled by three different acts. Number one, Capital Issues Control Act, Companies Act 56 and Securities Contract Regulation Act 56, which is commonly known as SCRA. Okay, so SEBI got its statutory power in 92 with the enactment of SEBI Act 92. So as I mentioned earlier, it has to be responsive to the needs of three groups. Number one, issuer of securities, that means the company. Number two, investors. Number three, market intermediaries. So as you know that SEBI is applicable to listed companies and companies which are proposing to get its securities listed. Okay, so between these two parties, that means in listed companies, the shares or securities of listed company will be subscribed by investors. So between these two parties, there will be intermediaries like stockbrokers, underwriters, depositories, depository participants, credit rating agencies, etc. Okay, so all these will be coming under the powers of SEBI. Okay, so SEBI has three functions which are rolled into one body. So SEBI is quasi-legislative, quasi-judicial and quasi-executive. That means SEBI is having power to draft regulation. So that is quasi-legislative. It will be passing rules and orders. So it is having the power of judicial power also. Then it is also having executive powers to conduct investigation and enforcement of any action. So as you know that in our country, these three pillars are different. But SEBI is having all these three powers. So you can imagine how powerful SEBI is. Okay, so we'll move to the objects of SEBI. So objects of SEBI, number one is protection of interest of investors in securities, promotion and development of securities market and regulation of securities market. So as I mentioned earlier, there are three groups. Number one, issuer of security, the company, listed companies. Number two, intermediaries. Number three, investors. So they will be protecting or they will be ensuring all the measures to protect the investors and they will be regulating the issuer and intermediary. Okay. So now the constitution of SEBI. So SEBI consists of a chairperson, then two members among officials of central government dealing in finance and administration, they will be nominated members. Then one member among official of RBI, that is also nominated, and five appointed members, out of which three members will be whole time. Okay, then terms of office and conditions. So chairman and whole-time members should not have any financial or other interests which are likely to affect their function prejudicially. Okay, then their term is 5 years, they are eligible for reappointment. Chairperson or whole-time member cannot hold office after the age of 65. So the maximum age is 65 for chairperson and whole-time members. Then when central government want to terminate the service of chairperson or the five members, appointed members, they can do the same by giving 3 months notice in writing or 3 months salary and allowances. Okay. On the same hand, members whole-time members or chairperson can relinquish their office or resign their office at any time by giving 3 months notice in writing. So it is possible both the ways. Okay, then removal of members. So we will be discussing the grounds for removal of members. So these grounds are similar to section 164 of Companies Act, disqualification of directors. Like number 1 is a person who is adjudicated as insolvent. Number 2, unsound mind and stand so declared by a competent court. Then a person who has been convicted for offence involving moral turpitude, unethical practices. Then person who has abused position against public interest in the opinion of central government. So before removing the members under section 7, reasonable opportunity of being heard should be given. Okay, now we'll move to meeting of SEBI. So all the decisions will be taken by majority. If chairperson is not present in a meeting, a member who is taken over or who is elected by other members will be presiding the meeting. Okay, in the case of equality of votes, the chairperson or person presiding shall have casting vote or second vote. Okay, if a member is director in any company or having pecuniary interest in any discussion, that director will not participate. That director will disclose his interest and should not take part in the meeting. Okay, so that is if a member of SEBI is director in any other company and that discussion is related to that company, that person should not attend that meeting. He can attend that meeting, but he cannot take part in the discussion or he cannot vote in that particular meeting. Okay, so section 8 are 3 conditions that will not invalidate the proceedings of SEBI. So if SEBI has ordered anything, these 3 will not affect the orders which are passed by SEBI. Number 1, any vacancy or defect in constitution of SEBI, any defect in appointment or any irregularity in the procedure of SEBI not affecting the merit of case. Okay, so after passing an order, if any of these 3 has happened, it will not be invalidating the proceedings which has already been made by SEBI. Okay, so now we'll move to the part related to powers and functions of SEBI. So powers and functions of SEBI is mentioned in section 11. So several sections, subsections are mentioned in section 11 related to powers and functions of SEBI. So first we will move to specific powers of SEBI, which is specified under section 11 subsection 2. So under 11 subsection 2 specific powers, there are 2 specific powers. Number 1 is regulatory powers, number 2 developmental powers or developmental functions. So first we will discuss regulatory functions. So number 1 is regulating the business of stock exchanges and secondary market, registering and regulating working of stock brokers, sub brokers, share transfer agents, banker to issue, registrar to issue, etc. So as I mentioned, these are the intermediaries associated with the securities market. Then promoting and regulating self-regulatory organizations like AMFI, like Association of Mutual Funds in India, Association of Merchant Bankers in India, that are the examples for self-regulatory organizations. Then prohibiting fraudulent and unfair trade practices relating to securities market, investor education and training, and prohibiting insider trading in securities. Okay, then regulation of substantial acquisition and takeover also. Okay, so these are the regulatory functions which is associated with SEBI. Moving to developmental functions, promoting investor education, training of intermediaries, conducting research and publishing information to all market participants, promotion of fair practices, then promotion of self-regulatory organization. Okay, so that was specific powers, section 11 subsection 2. Now we will move to power of SEBI to conduct inspection. So SEBI is having power to inspect books of listed company or any public company which is intending to get its securities listed. SEBI can exercise this power, that is the power of inspection can be exercised by SEBI under two grounds. Number one, if SEBI has reasonable grounds to believe that they have been indulging in insider trading or they have been actively participating in any fraudulent or unfair practices relating to securities market. Okay, so next is powers of SEBI when inquiry or investigation is ordered, pending or completed. So SEBI is having powers like suspending the trading of any security in recognized stock exchange. If any inquiry or inspection is ordered, is conducted or pending, SEBI is having power to suspend trading of a security. Then SEBI can restrain person from accessing stock market or prohibit any person associated with stock market to buy, sell, deal in securities. Okay, they can suspend the office bearers of any stock exchange or self-regulatory organization, impound and retain the proceedings of securities, attach properties or bank account of intermediaries for a maximum of 90 days. Okay, then direct any intermediary not to alienate or dispose any asset forming part of any investigation. Okay, so moving to penalties or power of SEBI to levy penalty. Okay, so it is mentioned in 11 subsection 4a and 11b also. Okay, so SEBI has power to levy penalty after holding inquiry. Then penalty may be imposed under section 15a to 15hb. So we will discuss each section one by one. So 15a is failure to furnish information, file return, maintain books. You can see that most of the penalty is common. Most of the penalty will be minimum rupees 1 lakh, which may extend to rupees 1 lakh per day subject to a maximum of 1 CR. Okay, so for CMA final examination in 2016 syllabus, you can check the previous question papers. So you will see that in most of the attempts, individual penalty has been asked under SEBI. Okay, so it is very easy to answer those questions because most of the penalty under section 15a to 15hp, most of the penalties are same. The quantum of penalty is same in most of the sections. Okay, so first one is failure to furnish information, file return, maintain books of accounts, and the penalty is minimum rupees 1 lakh, which may extend to rupees 1 lakh per day subject to maximum of 1 CR. Then 15b, failure to enter into agreement with client, minimum 1 lakh, which may extend to rupees 1 lakh per day subject to maximum of rupees 1 crore. Same penalty. Failure to redress investor grievances, same penalty. Then defaults in the case of mutual fund, same penalty. Failure to observe rules and regulations by asset management company, that is also same, 1 lakh, which may extend to rupees 1 lakh per day subject to maximum of 1 CR. Okay, now we will move to section 15F. There are three subsections in 15F or three specific conditions under 15F, which is related to stock brokers. Failure to issue contract note, minimum 1 lakh, maximum 1 CR. Failure to deliver security or make payment, 1 lakh, which may extend to 1 lakh per day subject to maximum of 1 CR, the same penalty. Then charging of excess brokerage, minimum rupees 1 lakh, maximum 5 times the brokerage. Okay, then insider trading, minimum rupees 10 lakh, which may extend to 25 CR or 3 times the profit made out of insider trading. Non-disclosure of acquisition of shares or takeover, minimum rupees 10 lakh, which may extend to rupees 25 CR or 3 times the profit, whichever is higher. Then fraudulent and unfair trade practices, minimum rupees 5 lakh, which may extend to 25 CR or 3 times the profit, whichever is higher. Then where no separate penalty under any of the sections are specified, the penalty will be minimum rupees 1 lakh and maximum rupees 1 crore. Okay, so I know that it is very difficult to remember the sections of penalty and all, but in this case if you are analyzing, you will understand that most of the penalties are same. Okay, so if questions are being asked for the examination, I think it will be easy for you to answer that questions. Okay, so next power is related to disgorged amount. So any disgorged amount shall be credited to IPEF. IPEF stands for Investor Protection and Education Fund, which is a fund established by SEBI. Okay, so regulation or prohibition of issue of prospectus, the powers which are related while a company is issuing prospectus. So SEBI may specify matters relating to issue of capital, transfer of securities, other matters, the manner in which such matters shall be disclosed by the company. Okay, SEBI can regulate matters relating to issue of capital, transfer of securities, other matters connected thereto, etc. Then SEBI may prohibit a company from issuing prospectus of a document, specify conditions for issue of prospectus, specify requirement for listing and transfer of securities. So these are the powers of SEBI which is related to issue of prospectus. Okay. Then next is power of SEBI to order investigation. So if SEBI has any reasonable ground to believe that transaction in securities are dealt in a manner against the interest of investors, or intermediary or any person associated with stock market has violated the provisions of Act, rules, regulation or direction. So under these two grounds, SEBI is having power to order investigation. Okay, so now we are moving to prohibition of manipulative and deceptive devices, insider trading, etc. Okay, so as you know, insider trading is buying or selling of securities when a person, connected person or insider is having access to unpublished price sensitive information of the company. Okay, so under section 12A, SEBI is having power to prohibit any manipulative or deceptive devices, contrivance in contravention of provisions of Act, rules, etc. If company is forming any devices to collect money, or if they are in a position to defraud the investors and all, SEBI is having power to prohibit that. Then they have power to prohibit any scheme, device or artifice to defraud, engage in activities which operate which would operate to fraud, insider trading, dealing in security while possession of non-public information, acquire control in contravention of provision. So when company is doing any of this activity, SEBI is having power to prohibit those activities. Okay, so now we'll move to procedure of adjudication under SEBI. Okay, so officer not below division chief, which is a post in SEBI, they will be appointed as adjudicating officer. Reasonable opportunity of being heard shall be given before or while doing the adjudication process. Okay, and SEBI is having power to enhance the penalty which is imposed by adjudicating officer within 3 months of order. So as we discussed, under section 15A to 15HB, there are several penalties which are mentioned, and if the adjudicating officer has levied a penalty, suppose adjudicating officer has levied the penalty of 25 lakh to a person, okay, under section 15A. So under section 15A, minimum penalty is 1 lakh, maximum 1 lakh per day subject to 1 CR. So SEBI is having power to enhance the penalty of 20 lakh which was imposed by the adjudicating authority within 3 months of order. Okay, then while giving penalty or while adjudging penalty, SEBI will be considering three aspects, or adjudicating officer will be considering three aspects. Number one, the amount of disproportionate gain or unfair advantage enjoyed by the other person. Okay, then the amount of loss caused to investor or group of investors, repetitive nature of default. Okay, so these factors will be considered because the penalty is mentioned like minimum is there and there is a maximum. So while considering the quantum of penalty, they will be considering, or they will be giving more focus to these three factors. Okay, so now we'll move to SAT, Security Appellate Tribunal. So SAT shall consist of a presiding officer, judicial members and technical members. Okay, so every bench shall include one judicial member and one technical member. Okay, so we'll move to the qualifications of presiding officer, judicial members and technical members. So presiding officer, the qualification is he is or has been a judge of Supreme Court, Chief Justice of High Court or Judge of High Court having minimum 7 years of experience. Then judicial member, the qualification is been or has been Judge of High Court for minimum of 5 years. So judicial member is or has been Judge of High Court for minimum 5 years. Technical member is or has been secretary, additional secretary in Ministry of Central Government or equivalent post in central government or state government. Person of ability, integrity, standing, having minimum 15 years of professional practical experience in financial sector. Okay, then their tenure of appointment, presiding officer and judicial member and technical members can be appointed for a term of 5 years. They are eligible for reappointment. They cannot be appointed or reappointed when they attain the maximum age of 70 years. Okay, then we'll move to the provision related to appeal to Securities Appellate Tribunal. Okay, so appeal can be preferred within 45 days from the orders of adjudicating officer, SEBI, IRDA or PFRDA. So if adjudicating authority, IRDA, PFRDA or SEBI has imposed any orders, you can prefer an appeal to SAT within 45 days. The appeal has to be disposed within a period of 6 months. Okay, so if the appeal or if the disposal of appeal or if the party is not happy with the procedure which is undertaken in the appeal, they can prefer appeal to Supreme Court within 60 days after passing of order by SAT. Okay, so the procedure is adjudicating officer will be imposing or SEBI will be adjudicating, SEBI will be passing any order. So that can be appealed within a period of 45 days to SAT, and if you are not happy or if you are aggrieved with the order of SAT, further appeal can be preferred to Supreme Court within a period of 60 days. Okay, so these are the provisions related to SEBI Act 92. So as I mentioned earlier, this session or this particular session is primarily focusing on CMA Final Students. So for CA Final Students and CS Executive Students, there are other topics also under this chapter. So we will be making separate sessions for those students. Okay, so we will be coming with a new topic in our new session. So thank you, take care and all the best for your examination.